And greetings. Welcome to Understanding Evidence, Judicial Notice, and Presumptions. And if we're all in here, if we could just let the YouTube universe know we are, and hit that like, and let's get the word out, get some people in the room, and let's start. Okay, we're going to be starting out with Judicial Notice. So let's go over Judicial Notice. Judicial Notice. This is one of the least used, yet potentially most powerful tools in any litigant's toolbox of lawsuit winning tools. And before we go along with any more of this, this broadcast is not to be used for anything professional, personal, legal, lawful, financial, or tax-wise. This is strictly for the entertainment, educational purposes of the YouTube broadcast. Don't do this at home. All right, let's proceed. Every jurisdiction we know of allows it, the judicial notice. However, very few lawyers use it, because perhaps in part, it makes the judges work harder. And lawyers often don't want to upset judges, that they'll be required to appear before again next week. That being said, this tutorial wasn't written for lawyers who have to appear before the same judge week after week, year after year. We're only concerned about winning your case, not maintaining a career relationship with a judge. Therefore, if we have to make the judge work just a bit harder to win our case, we'll have no hesitation to move the court to take judicial notice. But what does that mean? Take judicial notice of what? To explain, let me digress by telling a story of one of my first encounters with a real live fudge. My client moved out of her apartment, cleaned the floors, the walls, the inside of the oven. Everything was spick and span, tidy and clean as a pin. The landlord wouldn't return her security deposit, though, as a young attorney ready to champion any cause I could find, it seemed reasonable to sue the landlord in small claims court, demanding a return of my client's deposit. The landlord had no leg to stand on. We had photographs. We had witnesses who helped clean the apartment. Everything was better than the day my client moved in. The landlord, not to give up, however, complained, "But they cut down my Brazilian pepper tree, Judge," also known as Florida holly, but that's a misnomer. And I digress there. There at least was the root premise of the defense. My client had indeed cut down the plant, a no nuisance in Florida where this particular case was filed. Clearing my throat cautiously, I said to the good judge, "Your Honor, I move the court to take judicial notice that the Brazilian pepper plant is a nuisance in Florida, and that the defendant landlord had no pecuniary interest in retaining it as an ornamental plant or for any other purpose, so that my client was justified and altogether sensible in her decision to destroy the plant during her tenancy." And of course, a pecuniary interest involves money. And he had no money interest in maintaining a nuisance plant. A moment here. Just refreshing the chat, making sure everything has gone out. And that notifications went out this time, it seems. So let's continue. I'd never moved to court to take judicial notice before, so I didn't know exactly what to expect. To my delight, however, the judge leaned back in his stuffed leather chair and talked for what seemed like a good half hour, explaining his own experience with that pesky nuisance, and, at last, how the landlord would not be heard to complain about its destruction by my client, or be permitted to retain her security deposit upon the pretext that the plant had any monetary value whatsoever. And remember, the courts are most involved with money. Judicial notice is the obligation of a court to adjudge certain known facts upon the record of the case, provided that those facts are so generally known within the court's jurisdiction and capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned, that the fact need not be otherwise proved. A famous case reported to have been won by Abraham Lincoln before he became President of the United States involved the testimony of one who claimed to have witnessed a murder. The witness was so sure of his recollection that old Abe put him to a difficult test, asking him precisely how far away he stood at the time of the crime and how clearly he could identify the accused. The witness testified that although he was several dozen yards away and he could see clearly by the light of the full moon, Abe asked for a brief recess, during which time he consulted the Farmer's Almanac before returning to the court, where he prevailed upon the judge to take notice that upon the night of the murder there was a new moon, example, no moonlight whatsoever. The accused was set free. The court's notice was not based on opinion. The court's notice was not based on persuasive argument by counsel. The court's notice was based on the Farmer's Almanac, a source whose accuracy could not reasonably be questioned on the point. If there was no moon that night, the witness could not have identified the murderer with the precision he claimed. A court may take judicial notice, whether or not a party moves it to do so. The court has discretion whether or not to take judicial notice of some matters once it is moved to do so. However, in other matters, it has no discretion and must take notice once a party makes the motion. So this seems like a way you would consult your rules of procedure depending on the jurisdiction or court you're in. This distinction is important and will be examined closely. Let's hop on over to the chat and see what we got here. All right. No questions? Let's proceed. When the court has discretion to take notice, may, and we're not talking about the month, as stated above, a court may at any time on its own motion, that's called sua sponte, take judicial notice of any undisputed fact or law that applies to the case. Undisputed. This happens rarely, however it does happen. Though the court may not formally announce it is taking judicial notice and may merely make a statement such as, "The court is aware that the highway in question runs generally north and south through this county," or such like statements to move the parties along. In other cases, the court may go on record formally taking judicial notice. An example given here is judicial notice of the essential elements of a cause of action, or that a certain date fell on a weekend. The court may also be moved by a party to take judicial notice. However, unless the matter sought to be judicially noticed falls into one of the categories where the court has no discretion to deny the motion, the court may refuse to take judicial notice. Examples where the court has discretion include weather conditions on past dates, proper medical procedures to be followed in certain cases, or any such similar matters where reasonable persons might disagree as to particulars. When the court lacks discretion to take notice. When they don't have the discretion, there's shall. If moved to do so, a court does not have discretion to refuse to take judicial notice of facts that admit of no controversy, such as the phase of the moon mentioned above or controlling effect of a law within the court's jurisdiction. important one right there, the controlling effect of a law within the court's jurisdiction. If the fact sought to be judicially noticed can have no bearing on the outcome of the case, of course the court is not required to take notice. The fact must be relevant. If moved to do so, and notice is given to the other side along with sufficient information to enable the adverse party to prepare to meet the request, a court must take judicial notice of such things as acts and resolutions of Congress or the state legislature, the law of any state, contents of the Federal Register, laws of foreign nations or organizations of nations, official acts of any branch of government, rules of court, duly enacted ordinances, and general facts that are not subject to dispute, because they are generally known. An example given here again, the Brazilian pepper tree is a nuisance. Or because they are capable of accurate and ready determination by resort to resources whose accuracy cannot reasonably be questioned. Farmer's Almanac. Okay, keep in mind that the court is only required to take judicial notice of facts that are relevant to the case before it, and the party moving for judicial notice must provide the opposing party with sufficient information to prepare to meet the request, filing all such matters also with the court. Effect on the jury. So if we have a trial by jury, this would be an effect here. All matters judicially noticed should be communicated to the jury with instructions that the jury is to consider same as undisputed facts with regard to each and every matter the jury is called upon to decide. The jury thereupon has no discretion to disagree with a matter that has been judicially noticed as fact. That's an interesting one there, where the jury must take notice on every matter that applies to the case. And we're on to use and practice. And let's briefly jump over here onto the chat. Got some pretty thin chat here. I'm glad everyone's paying close attention. Let's continue. Use and practice. Like everything else in life, judicial notice could be overused and abused to the point of jeopardizing your case. There's no point in unnecessarily putting a judge to the necessity of taking judicial notice of matters only remotely related to your cause. On the other hand, if it is relevant to the outcome of your case to take notice that a corporation was administratively dissolved by the Secretary of State prior to it suing you, move the court to take judicial notice of the fact. Provide opposing parties sufficient documentation to allow them to consider the facts in support of your motion and filing all such documents with the court. Many times, cases can be speeded along and remaining facts dealt with much more expeditiously by moving the court to take judicial notice, rather than spending added time and costs calling witnesses to prove what cannot be reasonably disputed. All right, so we've covered judicial notice. I hope we all get that well understood. If there's any questions, let's hop over to chat. Good. This is a very well written tutorial, so let's continue. We're on to presumptions. This is an interesting area of evidence law that arises where a fact may be presumed once one or more facts are established on the record. Of course, the weight of a presumption depends on the credibility of underlying facts on which it is based. Some presumptions are rebuttable, while others are not. An example, they may be refuted and ignored if additional facts tend to undermine their reliability. Additional facts. Some presumptions arise as a matter of law, while others arise merely by inference. Educated guess. A clear distinction between presumptions and inferences will be made in this tutorial. The effect of presumptions often decides the outcome of lawsuits. However, too many cases are wrongly decided because inferences were permitted to be treated as presumptions. It is critically important, therefore, to understand the difference between inferences and legal presumptions. So let's figure this out here. Starting with inference. An inference, like a presumption, is an assumed fact. However, unlike a presumption, an inference arises not from the application of law, but from common sense reasoning, or, as too often happens, not so common sense guessing or wild conjecturing. For example, suppose you forget to walk the dog, and the dog leaves a mess for your wife to discover on the kitchen floor, and she exclaims in tones of hurt and disapproval, "How could you? You refused to walk the dog on purpose. You don't love me anymore." In fact, you may love your wife very much. You simply have other things on your mind, occasionally forget to walk the dog. Doesn't mean you don't love your wife or that you refuse to walk the dog on purpose. However, you did not walk the dog, and the mess on the kitchen floor is an unavoidable fact. Inferences will be made. Judges and juries are human too. We all make inferences from facts. We do it unconsciously. Sometimes we even infer new facts from known facts, then make inferences from our newly inferred facts. And the results are often catastrophically far from the truth. In court, the making of inferences often results in disaster, because inferences can be, and frequently are, extremely far from the truth. So this is a good one here. Sometimes we even infer new facts from known facts, and then make inferences from our newly inferred facts. Crazy. All right, but we all know that can happen, and unconsciously in many situations. Presumption. A presumption, on the other hand, is a fact that is established by operation of law, unlike the inference that results from the unrestrained human imagination. Presumptions are the product of courts and legislatures that decide certain facts that can be determined from other facts as a matter of law. For example, in Florida, we have what's called the carpenter presumption, a legal presumption that kicks in where a person of some degree of mental infirmity dies, leaving the bulk of his estate to someone who, 1, enjoyed a confidential relationship with the descendant, and who, 2, actively participated in procuring the will. When someone of some degree of mental infirmity dies, leaving the bulk of his estate to someone he enjoyed a confidential relationship with, who enjoyed a confidential relationship with a descendant, and who actively participated. By these two facts being proven, the carpenter presumption kicks in to require the party favored by the will to prove the descendant was not unduly influenced. An example, that the written will was a genuine expression of the descendant's will or intent, stating what the descendant would have written if he had not been the victim of undue influence. The effect of presumptions is to shift the burden to prove. You get that? The effect of the presumptions is to shift the burden to prove. In Florida, once the party presenting the will to probate demonstrates that the will is valid, properly executed and witnessed, the burden shifts to the party challenging the will to show that the two elements of the carpenter presumption exist. Once the elements are shown to exist, the burden shifts to the person seeking to establish the will to prove that there was no undue influence. If the person seeking to establish the will could show that there was no undue influence, the burden shifts back, and the presumption disappears. Burden shifting may not require a party to prove his case. It may suffice for him to merely present some degree of evidence to meet the presumption without overcoming it. This burden is sometimes called the burden of producing evidence. Consult your local rules for details. Whether a particular legal presumption shifts the burden to prove or merely the burden of producing evidence, the effect is the same. Presumptions shift burdens, and that's the burden to prove. In our footnote here, it is the burden of the party challenging the will to first prove that all elements of essential fact exist before the presumption kicks in to shift the burden to the party who procured the will. So, let's check the chat here before we continue. There are some presumptions about the home and unwarranted intrusions, but these get complicated. Yeah, there are quite a few, and they're good to know in whichever state you're living on, because that would be very clear about your limits of how much protection that you'll be able to do without any kind of legal recourse for protecting your property and your life. In some cases, if particular facts are established on the record, a legal presumption may be conclusive. An example, unrebuttable. As with particular facts established on the record. So particular facts, they're established and they're on the record. Then it may be a conclusive presumption, and that would be unrebuttable. The law will presume the outcome then and there. If facts supporting a conclusive presumption are shown to exist, the facts supporting it, there is nothing more for the court to decide. The presumption carries. Most presumptions, however, are rebuttable, and all arise from enacted law. And I believe this term here is a little bit loose. The number and nature of various presumptions are too numerous to list here. Consult your local law library to learn more about presumptions. Interesting here how it's referring to enacted law. All presumptions arise from enacted law. An interesting phrase and one to consider. And then, of course, the quantity, the number of various presumptions. Way too numerous to list. But, of course, those would be conditioned by your local customs and your local courts. So check your local library to learn more about presumptions. And I believe that brings us, yes, to the end of this episode here on presumptions in judicial notice, on our exploration of understanding evidence. And let's double check on the chat here and see what else we got. Once again, anyone else that's in here has been enjoying, please hit the like so that we make sure we get the notifications out next time I go. I had to do 2 tries to get it to come out this time. I'm glad y'all made it out. It seems like we're all going down this path to learn more about evidence and more ways of being able to use the courts for the purpose they were intended for, which is, of course, to have the rule of right. That being said, let's see what else we got here. Oh, yes, Lionel, thank you for coming and participating. Cartilage of a home, part of a presumption. I think curtilage, right? Curtilage, there you go. It typically is, I believe, that it's considered part of the property of your enjoyment and that there's a certain aspect of privacy to it, but at the same time, because it may be in public view, there's other aspects to those presumptions. So again, your local customs, your local rules, and again, the presumptions are decided by enacted laws. Laws are enacted with an enactment clause and are typically signed by a governor or some other one in charge of the executive branch of that governing body. So that's another thing to notice for judicial notice. Is it a presumption of law or is it a presumption of something that wasn't an enacted law, then it's not a presumption because, as we read, all presumptions come from enacted law. That being said, I thank you all for coming here and salute you all for spending the time to come on this journey. And I hope to see you all on the next one. Peace out.